Good morning, Mr. Ogwin.
Good morning. May it please the Court, Assistant Attorney General James Arguin on behalf of the Commonwealth. This appeal arises from the Superior Court's report of a question of law, whether Massport is a corporation within the meaning of General Laws, Chapter 266, Section 67, which prohibits false entries on corporate books. In dismissing the underlying indictment, the Superior Court found that Section 67's reference to corporation was ambiguous in that it could apply logically to either all corporations on the one hand or to only private for-profit corporations on the other hand. As
that doesn't seem to me to be a very common sense construction. And you have some legislative history that points in the other direction, right?
There's two things there. The fact is that the legislature chose specifically in Section 67 to define false entries in terms of any corporation. It didn't specify any particular type of corporation. And I think that's significant for several reasons. First, the statute, as the defendants have pointed out and as the Superior Court pointed out in other contexts, the legislature has made clear when they wanted a narrower construction of the term corporation by specifying particular types of corporations. Here, they didn't make that distinction. And I think it's also significant that in their brief on appeal, the defendant notes that in a footnote that there's no need to defend the Superior Court's distinction between for-profit and not-for-profit corporations.
Well, that's clearly incorrect, isn't it?
Yes, I think it is clearly incorrect, but that was the crux of the Superior Court's decision.
I understand that. I understand.
And it's also, though, it follows logically also that the defendant persists now in drawing a distinction between private corporations versus public corporations.
Well, could you explain to me how we can separate out Massport from the cities and towns?
Easily, Your Honor. First of all, what the defendant relies upon is a general rule of statutory construction that generally applies to cities and towns which are formed as municipal corporations, and they share the same legislative designations as bodies, politic, and corporate, but they serve entirely different purposes.
Why should that make any difference at all as to whether or not they're a corporation for purposes of this statute? Because they perform a variety of different services. Why should it make any difference?
I don't think it makes any difference. I think it's a corporation, as this Court has already said in opinion of the justices.
Someone altering the books of a city or a town would be...
I think they could, very well, Your Honor. Although I don't think that particular issue is presented here, but I think it certainly is logical to conclude that the legislature intended the term corporation to apply to all corporations, public and private. And bodies, politic, and corporate, as this Court has said in a series of opinions for the last century, include public corporations. They create a corporation separate and apart from the Commonwealth itself.
Would include municipal corporations.
I think it would. I think it very could. Although I point out the Court doesn't necessarily need to resolve that particular issue here, but I think it very logically could.
Massport wasn't created as a public corporation. It was created as a body, corporate, and politic, which is not the same thing, and it's a term of art.
Well, I disagree, Your Honor. If you go back for the last century, going back as early as the turn of the century to Horton versus Attorney General in 1929, and go through a series of opinions of the justices in terms of this legislative designation as body, politic, and corporate, repeatedly this Court has held in a variety of different contexts that creates a corporation separate and independent from the corporation, a corporation in its own right. And what they do is use that term to designate certain entities like Massport, like the Massachusetts Turnpike Authority, like the MBTA, local and regional,
MHMFA, I mean,
all kinds. And what they're trying to do is give those entities the flexibility of a private business entity, but make them responsible for carrying out critical public functions. As the appeals court noted in the Cargman decision, the two critical distinctions are that they have independent financial setups. They're run by their own boards of directors. They have also political independence in terms of they're not part of the machinery of government. And that's another critical distinction as to why the rule as applied to cities and towns may not necessarily apply here, because cities and towns are different.
Then how do you explain the use of the word public instrumentality in Chapter 266, Section 67A, where that term is precisely the way Massport is described in its enabling statute? And it appears as though 67A was enacted by the legislature in response to perhaps a gap in Section 67.
Well, 2 points. On the term public instrumentality, that is used in connection with the setup of Massport as a body politic and corporate, and I think it's only intended, as the justices said in their opinion in 1956, to describe the public function of the corporation. Its public function is to carry out certain specified mandates,
Why
operating
do
the
we
airport
need
and the
Section
bridges.
67A if Section 67 has the meaning you suggest?
Well, Section 67A is very different from Section 67. Section 67A is directed to a much narrower category of criminal wrongdoing.
Procurement.
Exactly. It's directed precisely to false statements relative to a State Department agency or public instrumentalities, procurement of services, supplies, and construction.
Mr. Gargwin, I accept that, but then why on these facts, how is it that, how do you say it, Biagiotti or
I believe it's Biagiotti, yes.
Biagiotti? How is it that the Commonwealth can charge Mr. Biagiotti under both of those statutes for the same act? I mean, it seems to me, if I accept your argument that they are doing different things, he either was procuring or he wasn't, and if he wasn't, and he fits, his activities fit within 67, assuming that it applies, how do they fit in within 67A?
Because both sections are applicable here. And I point out it's maybe a unique factor of the fact that Massport is a hybrid corporation with both private and public characteristics. But as applied here, both sections apply because it describes the nature of the criminal conduct that was at issue. And the Commonwealth is entitled to present the jury with as full a picture as possible of the criminal scheme that is at issue. And the first step
I mean,
in
it's
this
all
scheme,
covered by 67A?
it is covered both by 67 and 67A, as well as conspiracy to commit theft. And let me, if I could just walk it through. The first step in what the Commonwealth's allegations against this defendant are is that he made a false entry on the books of a person, firm, or corporation, Massport. The second step in that transaction was that that false statement was used in connection with the procurement of services from a third-party contractor, the International Association of Longshoremen.
But they had already been procured. This was just payroll, wasn't it?
This was a change in the timesheet, the books of the
I mean,
corporation.
it wasn't. I think of procurement of services as purchasing services. These services, these people were already working.
But these are services provided on the problem. The false statement here is about who was performing the services. So they used a false statement in connection with the procurement of services from the longshoremen. And that false statement in the third step of this was actually used to steal money from Massport in the form of increased benefits that the defendants were not entitled to.
So your theory is he could be charged under both statutes? am I
Under
right?
this circumstance, he can, but I think contrary to what the defendant argues in his brief, it's certainly not true that Section 67 and 67A are somehow interchangeable. They prohibit discrete categories of criminal conduct, and that's simply false. That's simply false. That not all false entries in a corporate books will result or be made in connection with the procurement of services.
Well,
or
if the
supplies.
legislature had intended to include public instrumentalities such as Massport or other authorities, wouldn't it have been very easy to have said so in Section 67?
But it was
But
written in the 19th century and amended in 1911 or something? I mean,
It was written in
Could have been
1856 and
amended
amended in
since then to
1885.
include.
And I think the point is clear that it's just the opposite, Your Honor. If they intended it to exclude public corporations, then they could have made it express as they had done in other sections.
What does 67A say? What
67A refers to false statements relative to a State Department agency or public instrumentalities.
And so when they were writing 67A, it would have been very easy to amend 67 to add public instrumentalities if they wanted to include them.
But I think the proper focus is not what the legislature intended. It's what the legislature intended when it created Massport in 1956. When it created Massport in 1956, it did so knowing full well, as this court had opined.
I take it, Mr. Ogren, that one way that you can reconcile it is that the legislature's created a hybrid, right? It's not
Yes.
a body politic. It's a body politic and corporate, right? There's certain things that the legislature has said that if you do this in a corporation, public or private, namely false entries, right, that's ground for a criminal indictment. In a private corporation, in other words, leaving aside the public instrumentality, the body politic, the government isn't interested in how you procure. your services, other than if it violates the antitrust laws or something like that. Then there's a whole set of laws about that. They don't care, right? They care for the body politic, how you procure. So 67 is going to the corporate piece, 67A is going to the body politic piece. I mean, they're not inconsistent.
I don't believe they're inconsistent, but I don't think they're mutually exclusive either.
They're not mutually
You
exclusive.
could certainly have a false statement on the books of a
Of course.
corporation that is not
I'm
related
agreeing,
to
I'm
procurement.
agreeing with you. I'm
Okay.
explaining.
Well, thank you, Your Honor.
Maybe I'm not being very articulate about it, but in other words, the conduct that's included in 67 goes to a corporation. It doesn't go to it doesn't go to the doing of the public business.
I think that's absolutely correct. And I think that's exactly why the general rule of construction that the Superior Court and the defendants relied upon is completely inapplicable here.
And you say that the key, in terms of looking at legislative intent and legislative history, you look at the establishment of Massport and whether in the wording of that statute, that legislation, they intended Massport to be a corporation for purposes of Section 67?
I think what we have to look at is, at the time they formed Massport, what was the state of the law in terms of what was a corporation? They are charged, obviously, the legislature is charged with knowing the state of the law as it existed when at the time of a new legislative enactment. The state of the law in Massachusetts for the past 100 years had been false entries on the books of a corporation are prohibited and subject to criminal liability under Section 67.
How does that help? Go ahead, I'm sorry. Continue.
Well, when they created Massport, they created it specifically as a body politic and corporate, and they asked this court's opinion as to what that designation would mean. And consistent with a long line of authority here in the Commonwealth of Massachusetts in terms of what was a body politic and corporate, this court said in no uncertain terms that creating Massport as a body politic and corporate was creating an entity in itself with an existence separate and apart from the Commonwealth, and that nothing other than a corporation would seem to fit the bill. In fact, it described specifically the bill that created Massport as itself an act of incorporation. So, having with that scheme in mind, with the express opinion of the justices.
And what kind of history had there been with respect to the interpretation of the terms body politic and corporate with respect to cities and towns, which were also created as
Well,
body
prior,
politic and corporate?
tracing the history of that, the Cargman decision in the appeals court has a long history of that, and it traces the use of that phrase back to the Constitution itself, of the state Constitution. And it created, when the boundaries of the cities and towns were created, that designation was also used for municipal corporations in cities and towns. But as Cargman pointed out, there was a new use to that that developed around the turn of the century with respect to specifically these public corporate entities that were charged with carrying out critical public functions, but that the legislature chose, for several reasons, not to include as part of the infrastructure of government. So they set them apart with their own corporate structure, but held them responsible to the public because they were carrying out critical public functions. That's why they're a hybrid. But they have a long and settled history in Massachusetts, and this court's own opinions, as I said, for the last century have said repeatedly that that designation creates separate and independent corporations.
Mr. Arvin, I'm sorry, finish what you're going to say.
Well, the point I was going to make is that I think the critical distinction between the general rule of construction and why it doesn't apply here is that in every time that general rule of construction that says basically a statutory reference to corporation doesn't include cities or towns, it's been invoked where the statute in question was directed to regulate the conduct of a city or a town or to impose liability against a city or a town carrying out public functions. It has no application here because the statute here is directed against the individual conduct of those who make false entries on corporate books. And there's no reason to believe that the legislature intended to treat corporate victims any differently, whether they were organized to carry out private for-profit functions, private non-profit functions, or public functions like Massport.
My question is this. Given that there are statutes that, like 67A, that use the term, whatever it is,
Public instrumentality.
public instrumentality, and given a sort of history of ambiguity about how corporation is used sometimes, what do you do about the rule of lenity here?
Well, I don't think you get to the rule of lenity unless the court first concludes, based on its interpretation of the plain language of the statute, the purpose of the statute, and all the surrounding language, that an ambiguity exists. You cannot do what the Superior Court did here, which was used to use the rule of lenity to create an ambiguity where none exists. The criminal statutes, no less than civil statutes, are entitled to a reasonable construction.
I guess I'm just suggesting that maybe, if you look at the larger picture, but maybe you're saying you can't look at the larger picture. You're just saying if you just look at this statute, there's no ambiguity.
I think if you look...
It's hard to sort of, you know, keep out of your vision 67A or other statutes that use a term that might apply more specifically to something like Massport.
Well, 2 points. I think you must construe the statute first according to its plain language. And if that discloses no ambiguity, then the rule of lenity doesn't arise. And secondly, I don't think it's inconsistent, as we pointed out, to have both a charge, because of the hybrid nature of Massport, to have both a charge under Section 67 as well as a charge under 67A. As we pointed out,
Using the language in 67A is very specific about public instrumentality.
I think 67. Well, here's probably one explanation. Is 67A is, if you look at the statutory language, is directed to procurement relating to a State Department or agency. The general rule of construction that the defendant relies on would probably apply there because it's related to the regulation of a state entity. To make it specific that they intended to include these quasi-public corporations like Massport within the reach of those procurement fraud statutes, they added the specific language. I think that shows it's consistent with the general rule of construction that where a statute is intended to regulate or impose liability against a public entity, it must be expressed. But again, that is not the purpose of 67. 67 is not directed against the actions of any corporation. It's intended to protect corporations. And it simply makes no sense to treat a public corporation like Massport and all the other bodies, politic and corporate, that carry out critical public functions any differently than a private corporation. They should not be left more vulnerable to false entries in corporate books than their private counterparts. And that's the fundamental flaw in the Superior Court's decision. And for that reason, the Superior Court's judgment should be, the dismissal of the indictment should be reversed, and the court should answer the affirmative question, the question presented in the affirmative. Thank you.
Thank you, Mr. Ogden. Ms. Starkey?
Good morning. May it please the Court, Carol Starkey from the law firm of Conn Cavanaugh, Rosenthal, Peisch & Ford, representing defendant appellee Francis Biagiotti. There are 2 reasons why this Court should affirm the Superior Court's decision to dismiss the indictment against Mr. Biagiotti. First, because Section 67 unambiguously provides that Massport is not a corporation protected by Section 67. And second, and in no way conceding that first point, even if this Court is not convinced of the authorities, which they should be, that is in Mr. Biagiotti's papers, that Massport is not a corporation for the purposes of Section 67, the indictment against Mr. Biagiotti still should be dismissed, and that is because Biagiotti has established a plausible ambiguity as to the term corporation in Section 67, such that the rule of lenity demands 67 be strictly construed against the Commonwealth.
Ms. Starkey, as you know, this Court has said that Massport is a corporation. So it's a corporation for what purposes?
Your Honor, if we look to the enabling statute of Massport, which is what my brother spoke to, it in fact nowhere refers to Massport as a corporation.
No, I understand. I'm talking about this Court's interpretation of what the body politic and corporate means in that context. It says, inasmuch as, in our opinion, the Massport Authority be established by the would be a corporation. I'm just asking you, it's a corporation for what purposes?
Well, in Cargman, this Court also said, when it was interpreting what Massport was, that absent a plain meaning in the statutory direction, it devolves upon the courts to decide on a case-by-case basis whether a particular body politic and corporate, such as Massport would be, should be treated as more private than public.
Private and public has got nothing to do with this. In other words, whether if it's a public corporation and it's not a body politic, it's just a public corporation as opposed to a private corporation, whatever that distinction means, that doesn't implicate 67. It's the hybrid nature of body politic and corporate here. So the fact that it's a hybrid doesn't mean that you look to whether it's a private corporation or a public corporation.
In this particular case, the hybrid nature of Massport, though, points in the direction of it being a public corporation that is not protected by Section 67.
And that is because
and
why?
This is why.
Why?
Because in the enabling statute of Massport, it speaks in the second paragraph to the fact that this statute is created, or the authority is created, by being appointed by the governor, each member of whom must be removed by the governor.
Yeah, but if you get away from that structure and you look at the operation of the business of Massport, isn't it precisely the business model, the corporate business model that's followed here? They're engaged in a business to provide a particular kind of service that deals with commerce. Shouldn't we look at the books of this corporation just as we would look at the books of any corporation that would be carrying on this activity? And that's exactly what the statute is designed to protect.
The statute is designed to protect corporations, but it does not in anywhere state.
Would you agree with the Superior Court judge that she is incorrect to make a distinction between a for-profit and not-for-profit corporation?
The distinction should be between public corporation
you
and
agree
private
that she
corporation.
is incorrect?
I don't think the court has to follow necessarily the Superior Court's reasoning
did you
of
argue-
for-profit corporations only. And that's because what her analytical framework that
Did
she
you make
followed
that
was
argument
correct.
to her?
Excuse me?
Did you make the argument to her
No, I did not.
so that was a sua sponte?
I
basis
did
of-
not argue before her. I'm not precisely certain how she came about that decision, but I do know that in...
No, I wasn't asking whether you personally argued. Did your client argue that the statute doesn't apply to not-for-profit corporations?
What we were arguing in the lower court, as we're arguing before this court, is that Section 67 covers the private corporations, and in nowhere does it cover a hybrid such as Massport in a public corporate sense. And if we look to the criminal nature of statutes, we know that the ordinary and usual meaning of the term is what is important for this court to interpret every single term within a criminal penal statute, such as 67, which carries a 10-year prison term. Section 67 does not refer to and does not delineate private corporation. And my brother's argument that, in fact, if the legislature wanted to delineate it as such, it would include the adjective private corporation. But just the opposite is true, because if
Starkey,
you...
forgive me for interrupting you, but it's really my first question to you. The legislature obviously saw some benefit to having a corporation established. In other words, Massport is not a public agency. It's not part of the executive branch. It's a separate entity. It could have been called just a body politic, but the legislature saw fit to give it a corporate form. Once it gave it that corporate form, why should we conclude that existing legislation that criminalizes conduct, which it would appear to injure the corporation even more so if it's a, quote, public corporation? In other words, if we're going to protect private corporations, why would we assume that the legislature didn't want to give the same protection to public corporations, where there's nothing in 67 that says it's limited to private corporations?
Your Honor, if following the Commonwealth's argument that corporation and body politic and corporate are synonymous, essentially...
No, they're not.
...flies in the face of the statutory construction of
But
this
just
court.
answer my question. From a legislative intent point of view, why is it preferable from the legislature to say it's criminal conduct for an employee to fix the books of a private corporation, but when it comes to public corporations, we don't care. They can go ahead and fix the books?
The legislature intent is clear because this particular statute was created 100 years before the Massport's enabling statute in 1856. It was amended once in 1912. In 1950 and beyond, the legislature created 8 separate statutes where they delineated in their definition section of person the definition of person including public and also quasi-public or public corporations. In that, the legislature made a point to delineate that definition, beginning in 1950 and moving forward in 8 other separate statutes. Here they clearly did not anticipate that in the statute that was a Reconstruction-era statute of Section 67. Massport is a hybrid quasi or public instrumentality that is also called a body corporate and public, or body politic and corporate. And those two terms cannot be seen as synonymous, because even this court, when the legislature first noted the term body politic and corporate, noted that in 1786 that was discussing Massachusetts municipalities, the borders of Massachusetts towns. There are cases that discuss Massport and other public agencies that refer to public corporations or body politics and corporate. But Section 67 does not prohibit false entries in body politics and corporate. They prohibit false entries in the books of a corporation.
But Mr. Arguin points out that dictionaries around the time when this statute was enacted define corporation as including bodies politic and corporate.
And once again, this is a penal statute, and when construing criminal statutes, Your Honor, the words and phrases have to be given their ordinary meaning, and that means their contemporary meaning, so that a person living today would understand the phrase.
Chief Justice's question, don't we? Why wouldn't the legislature? What could be the legislative policy behind not including public corporation within this statute?
Once again, if the legislature, not only in creating those 8 other statutes,
yes,
but also
this one
created
was already on the books,
also
right?
created just adjacent to Section 67, 67A. And 67A speaks specifically to public instrumentalities.
It doesn't talk about body politics and corporate. And my question to Mr. Arguin, which was obviously very confusing because he didn't know I was supporting him, is the following. There are lots of reasons why a legislature might want to criminalize the conduct that is in fact criminalized under 67, in other words, false entries in corporations. One reason why you might want to do that is because you are trying to protect shareholders, you're trying to protect the corporation. So it doesn't really matter whether it's a public or private corporation. It's very hard for me, just off the top of my head, to understand why the legislature would want to criminalize some conduct for the procurement when you've got a, quote, private corporation. In other words, there are other things, as I suggested, that regulate that, like you can't do it in violation of the antitrust laws. But other than that, our law of contracts essentially says a willing buyer and a willing seller in the private world, go right ahead and do whatever you want to do, not when it comes to procuring for public. So it seems to me that the one way to read these is to say under 67A, the legislature is dealing with the public instrumentality piece of the hybrid, and under 67 it's dealing with the corporate piece of the hybrid. So there's no inconsistency in making an employee of a hybrid entity subject to both 67 and 67A. They're just not inconsistent. One deals with the corporate piece of the hybrid, the other deals with the public instrumentality. I would have greater difficulty, frankly, if 67A said body politic or corporate, because that would suggest to me that that means something different from corporate under 67. But here it's perfectly clear. It's public instrumentality. It's the public piece. And I have no doubt that if there was an attempt to deal with a body politic and corporate under 67A, and somebody came in and said, no, we're not a public instrumentality, we're just a corporation, that argument wouldn't hold sway.
Well, this particular set of facts is very simple. This is arising from a single alleged false statement in a Massport timesheet. That is the conduct that has been indicted.
And are you saying, I just want to be clear on this, are you saying that it is not a crime to make a false entry in the books of Massport?
No, I'm saying exactly the opposite, sir, that in fact 67A speaks to that specifically. That 67A, in fact, covers public instrumentalities and has a lesser penalty provision. And if we look to the legislative history of 67A, it also gives us some indicia, further indicia, that they were dealing with fraud against the government in this context. Because in a proposed bill of 67A, they specifically stated, it wasn't adopted, that it was dealing with state departments. And the conduct of 67A certainly covers the same conduct that arises here. And the Commonwealth has indicted Mr. Biagiotti for the alleged act of a single alleged wrong, false writing on a Massport timesheet.
But Ms.
That is
Starkey,
what we're dealing with.
But you would agree, would you not, that the scope of these two statutes, forget the public-private issue, the scope of these two statutes is very different. One is dealing with matters relating to procurement. The other is much more general. Isn't that so?
One is dealing with false entries in corporate books, and as we see it in the criminal statutes, if you look at the ordinary and usual meaning of the word corporation in Section 67, which was enacted at a time 100 years before Massport ever came into being, that particular statute speaks to private corporations and in fact references private corporations in its second paragraph.
I think Justice Botsford's question was the scope, not the entities that it covers, because we understand your argument, but the scope of the conduct that is prohibited is far broader under 67 than it is under 67A. The scope of the conduct, correct?
The scope of conduct is essentially covered, we would maintain, by both statutes, Section 67 and Section 67A.
Not what's charged with Mr. Biagiotti, but just as a general matter, an entry, a false entry in a corporate book that had nothing to do with procurement would be covered by 67 but not by 67A. Isn't that so?
In a public instrumentality in Section 67, I'm not certain I'm understanding the Justice's question. What we're arguing is that Section 67, the conduct that's covered by Section 67 and Section 67A, overlaps significantly, and that the legislature could not have intended such a broad overlap of penalizing the same type of conduct, but for the fact they were attempting to address a gap, and that gap was to penalize the same type of conduct for fraud against the government, or what would be better known as public instrumentalities. And they've specifically addressed that term within Section 67A. I see that my time
Ms. Starkey,
is up. I would simply...
I have one question, which goes back to a question that Justice Botsford asked Mr. Arguin, which is, there's a false entry made here, alleged false entry. 67A talks about relative to procurement of supplies. It seems to me that one possible reading, and I'd like you to tell me why this is correct or incorrect, is the procurement before the supplies have been delivered. It's the procurement of them. So all the little 1, 2, 3, 4, 5 goes to what I'm telling somebody before I procure them. In this case, as I understand it, the services, as Justice Botsford, that was her question, the services had already been provided by the father, correct?
Correct.
Why does 67A apply here, and have you made that argument?
Well, 67 essentially...
67A,
excuse me, accounts for making a material statement that is false in the procurement of supplies. Now, if I understand your question correctly, you're stating that it should be limited simply to the statement, the false statement in the Massport timesheet. My brother argues that...
That's not my question. My question is, as I understand it, and maybe I have the facts incorrect, the false statement, alleged false statement, was made after the services had been provided. Am I not correct that it
That's
was
not correct, Your Honor. After the services have been provided, there was a incorrect statement in a Massport timesheet. That timesheet then was part of a payroll packet that then was submitted to a payroll service used by Massport. And it is the Commonwealth's allegation that it is that payroll packet that went to the payroll service that then paid for services that were not actually obtained, or benefits, allowed for benefits that were not actually obtained.
Thank you, Ms. Starkey.
Thank you, Your Honor. I would just point out to the justices that even if the court is not convinced of these authorities, that the rule of lenity and the analytical framework used by the lower court was correctly applied, and we would ask for Mr. Biagiotti's indictment to still be dismissed even on that ground. Thank you very much.